cannot be the only one that is so annoyed and bothered by this woman actually being elevated to the Supreme Court, where it's a lifetime appointment. So there's no getting rid of her. But if you listen to her speak, like she's talking about birthright citizenship and all the legal backgrounds that they're discussing, my God, this like for real.
She is making nutty statements. And I think to your point, initially it was on the conservative side saying this doesn't make sense. She's not making legal arguments. And that's the problem I have. It's one thing if her arguments hung on some random case and said, if you look back through case history, Andrew versus Sean, it says this, and therefore this legal principle violates what we're trying to do. She is using politically charged language and saying this is wrong. It's an outrage. What did she say yesterday about Trump's decision? He's taking a wrecking ball. That's a political statement. That's not one based in judicial prudence or, case law.
I urge all of the people who are listening to and watching this interview, this conversation, to read her dissents, because one of the reasons why I was so supportive and advocated for her being on the court is I knew that at this moment in time, she would be in the minority.
She advocated because Ketanji Brown Jackson is a DEI hire, just like she was a DEI hire to be VP.
And that we needed someone who had the ability to deconstruct the complexities of law, deconstruct the concepts that we have about what is justice, what is equality, what is fairness, and do it in a way that is grounded in precedent and legal precedent, but in a way that speaks to the American people. I encourage everyone, when you have time, to read her dissents. They are brilliant, they are beautiful, they are pointed.
And they have heartbeat.
Oh, absolutely right.
What's going on, everybody? I appreciate you guys pulling up today, man. We got to talk about what went down today at the Supreme Court regarding birthright citizenship, because this isn't just politics. This is about the identity and integrity of a nation, our nation. Now, we've already touched on this before, but let's be clear. The left is in full-blown panic mode right now because there's a real possibility that the Supreme Court could take a hard look, maybe even a sledgehammer, to the long-standing interpretation of birthright citizenship that has allowed what many call anchor babies. What's the other word I'm looking for? People that have come over here on vacation to make sure that they can have their kids here. They call it tourism, birthism, or tourist births or something along those lines. And these kids, they become automatic citizens because of the loophole that if you are born here in the United States, you become a citizen automatically. And for decades, we've seen a system where individuals cross the border illegally. They come over here, via birth tourism and have children on U.S. soil. And those children are granted full citizenship. That interpretation has created what many view as a loophole, one that's been exploited over and over and over again. So much so that it is big business. There are people that are profiting off of this. There were a couple out in California that was just arrested, tried, and convicted of a business around birther tourism. Mainly people coming from China, coming over here, paying thousands of dollars to get set up so they can have a kid right here in our country. And here's the truth. Every nation has the right to define its borders and its citizenship. That's not radical. That's called sovereignty. Even scripture speaks to the importance of order, structure, and boundaries within a nation. Let all things be done decently and in order. That's in 1 Corinthians 14:40. A nation without order is a nation in chaos. And when laws are stretched beyond their original intent, you don't get justice, you get confusion. Now, the Trump's administration's move here is strategic. This executive action, it wasn't just about policy, it was about forcing the issue to the highest court in the land. It's about asking a fundamental question. What did the 14th Amendment actually mean when it was written? And does it apply in the way it's currently being used today? I don't think it does. Because scripture also reminds us, woe unto those that call evil good and good evil, but put darkness before light and light before darkness. When systems are manipulated and truth gets blurred and you have to step back and re-examine what's right, at the end of the day, this isn't about being harsh. It's about being just. It's about aligning policy with principle. And right now, the Supreme Court is being asked to do exactly that. Hit the like button, share the video, subscribe to the channel. We got to get into it. Let's go.
I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a U.S. citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law? I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense.
What the heck is she talking about? Seriously. Again, it goes back to the opening clip here. A lot of her statements aren't based off of, any previous case law. They're not based on any cases that have set precedents. They're all like these woke thoughts and feelings, but no real, there's no real context around, any case that's ever been presented before. And you get this a lot with this lady. This is also the same person that said being black is similar to being or equivalent to being disabled. It's the craziest thing ever. And I know you're going to get people on the internet caping for this woman, like Jasmine Crockett. She throws a message out on X earlier today, says a meltdown over Justice Ketanji Brown Jackson is truly something everyone needs to pay attention to. You see, as the first and only black woman to ever serve on the court, she had to be 10 times better than most. She continues to flex her brilliance in oral arguments and many dissents. I get it. The sisterhood, for the most part, they gonna stick together. But can somebody please call this foolishness out? If Ketanji Brown Jackson isn't the poster child for a DEI hire, I haven't heard one dissent from her that made sense. Not one. Every time there is a big case like this and it comes up and she has the ability to speak, she gets the floor. It's always something off the wall, crazy, and never aligned with the Constitution, and also not backed by other cases. It is the craziest thing. But yet you get people like Jasmine Crockett and so many others, they're going to come out and cape for this lady because she is the quote unquote first black woman that they have put into the Supreme Court justice. How about be good? How about not just be the first, but actually go in there and be good? You look at Justice Thomas, solid. His dissents, they're on point. And he is what a Supreme Court justice is supposed to look like and sound like. This lady, I have no idea. But people don't want to talk about the fact when they talk about Ketanji Brown Jackson, something they don't want you guys to remember is before all of this, and all this quote unquote history being made, there was a black woman by the name of Janice Rogers Brown, brilliant, unapologetic, and conservative. And she was in position. Now, again, she wasn't nominated to the Supreme Court, but when she was elevated to one of the most powerful courts in the country, guess who stood in the way? Democrats, to include Joe Biden. See, this issue was never about representation. It was about ideology. Because when you don't think like them, When you don't vote like them, suddenly your blackness, it doesn't count. And that's the part that they leave out of the story all of the time. And the reason why she didn't get the nod, because the word is that she was going to get the nod, but they did not think that they would be able to get her through the nomination process, not because she's a black woman, but because she is a conservative. People are being forced to make a decision. I know you got folks out there that's pro-black and they want to tell you that it's about blackness, but it's not. And we're seeing things play out in our faces every day to let it be known that it is not about how much or how little melanin you have, but it's about your ideology and your thinking. They're telling us this on a day-to-day basis. There are more and more examples that are being showcased. It seems like 2026 is the year that has really made that just super blatant. But let's keep going.
That when we look at this court's case law, and no one I think has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate, and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right because, obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what about the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right. Well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are, and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this Amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile. So it followed every 19th century.
That assumes domicile is in the test. And I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
When you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Mueller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice, we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
It is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not. They have that allegiance, and I think it's powerfully
on the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What do you do with Won Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says domicile.
Won Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, Social Security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a Social Security number. SSA says, look, a Social Security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a Social Security number, provided that the system automatically checks the immigration status of the parents parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
First off, I want to say this. Ketanji Brown Jackson's place in the Supreme Court is to push the far left progressive agenda. That is her job. It's not to uphold the Constitution. It's not to make sure that our government is operating, according to the Constitution. No, her job is to push the far left progressive agenda through the highest courts in the land. That's her job. But let me say this plainly. Saar didn't just win that argument. He didn't. He reframed the entire conversation. He pointed straight back to the original intent behind the 14th Amendment, jurisdiction tied to allegiance. That's the real debate here. Now, from a legal standpoint, the court is being asked to clarify what subject to the jurisdiction thereof actually means, not to retroactively strip citizenship or create some kind of mass denaturalization program. That is not the game plan here. It's not. As much as they would like to frame it and try to scare people, that's not the game plan. That kind of outcome would face serious constitutional challenges and hasn't been established policy, and it would be a nightmare to do it. It would be crazy to do it, to be honest with you. It would be a political mess to do this. But what is happening is this. A serious question is finally being put in front of the Supreme Court, in front of the Supreme Court. Does birthright citizenship apply universally, or does it require a deeper legal connection to the United States? And that's the that's the fight right there. And depending on how the court rules, it could reshape immigration law moving forward, but not rewrite history overnight. And that's what people need to understand. I am against birthright citizenship. The 14th Amendment was not meant to just universally grandfather people into our country because they got here and had a kid. That's not what it's about. And to be honest with you, I'm not at a point where I'm ready to say anybody that, gained their citizenship in that way, we should strip it away from them. But going forward, we should put a stop to it. Going forward, if you are here, great. Shout out to you. You got your citizenship. But moving forward, we can't have people come through our borders illegally, have a kid, and all of a sudden that kid becomes a citizen. And then when it's time to get deported, you get the media, the legacy media that is, saying they're deporting U.S. citizens because there is a kid who is attached to two illegal immigrants, one or two illegal immigrants that are being deported. That's the big issue right there. That's the big deal. Everybody knows that the 14th Amendment was the bill that basically guaranteed the enslaved people citizenship in perpetuity in this nation. Everybody knows this. But for whatever reason, actually, I can't say for whatever reason, we know why. The left is insisting that this maintain, because they need their new voter block and they need to be able to import their new voter block. I want to hear from you guys in the comment section. What are your thoughts on any of this? Hit the like button, share the video, subscribe to the channel, turn the notifications on to all so you never miss an upload. Consider joining the ARP family or buy your brother a coffee. That link's in the description box below. And as always, keep God first. Stay prayed up. We'll catch up with you guys next time. Peace.
It is God who arms me with strength. Yeah, I'm battle ready. He trains my hands for battle. My heart stays steady. But thanks be to God, he gives us the victory. Through my Lord Jesus Christ, fear can't live in me. I was down to the dirt, red clay on my shoes, old pain in my shirt, oh so bruised. In the Lord hit my chest, kicked death from my breath, put power in my step.